Thank you, Judge Hagerty. Please welcome Mr. Charles DeMakis, owner of DeMakis Law in Minot, North Dakota. He will be presenting on lapsed and abandoned minerals in North Dakota.
Good morning. My name is Charles DeMakis. I practice in Minot. I'm a 2004 UND law grad, and I've been in private practice for about 9 years now. Like most North Dakota lawyers, I'm a general practitioner, but in the last 3 to 5 years, I've focused my practice primarily in oil and gas. I've handled probably hundreds of lease negotiations, along with hundreds of curative actions for mineral owners. And I do division order drilling title opinion work for a couple of operators in the Bakken as well. So this morning we're going to talk a little bit about abandoned and lapsed minerals in North Dakota. And this is an interesting area of the law in the sense that we're seeing a lot more of it, particularly a few years back where surface owners were attempting to reclaim minerals that had previously been severed. In full disclosure, my examples constitute the relevance of the Dallas Cowboys. I'm a big Dallas Cowboys fan, so to you Vikings fans, I apologize. I'm going to give you just a basic introduction on minerals. I know there's a lot of attorneys in the room and a lot of land professionals, so if it's a little remedial, I apologize, but it should give a good background to those not as familiar. So there are two different types of mineral ownership, the first being fee simple, and in our example here, we have Jerry Jones owns all the surface and minerals in and under Cowboy Stadium. That would be fee simple ownership. He owns the whole. The other type of mineral ownership is the severed mineral interest. In the example here, we see Jerry owns all the surface, but Roger Staubach, Troy Aikman, and Tony Romo own all the minerals. And they may have been severed through two different types of ways. The first being a conveyance. Jerry conveys to Troy Aikman all the oil, gas, and minerals in and under Cowboy Stadium. Now Jerry owns the surface, and Aikman owns the minerals. They've now been severed, two separate estates. And the other way, the basic way, is a reservation, where Jerry conveys to Tony Romo all of his interest in the surface, reserving one half of the oil, gas, and minerals in and under Cowboy Stadium. Here, now, Jerry and Tony own the minerals, and Jerry owns the surface. So that's your basic type of mineral ownership. And why is this important, you ask? Because only a severed mineral interest can lapse. If you're the surface owner, obviously your interest isn't going to lapse. You own the surface. So that gets us into the North Dakota Century Code statute, section 3818.1. 3818.1 is the termination of mineral interest, or the abandoned mineral statute. And it states that if a mineral if it's unused for a period of 20 years, immediately preceding the publication of the notice of lapse, it's deemed to be abandoned. And title to these minerals vests immediately in the surface owner, under which the mineral interest is located. And the basic purpose, as you can see, is to reunite severed mineral interests with the surface estate. And it puts the onus on the owners of the severed mineral interests to actually do something. You know, in the 50s and even in the 80s, a number of mineral interests were sold. And, you know, as people get older, we end up with people dying. They forget about them. Grandkids, so on and so forth, end up with them, and they have no idea. So that's the point behind this. So the ultimate issue is, well, what is a mineral interest? Mineral interest is any interest in oil, gas, clay, gravel, uranium, or other minerals of any kind or nature created by grant, assignment, reservation, or otherwise owned by a person other than the owner of the surface estate. Now the interesting thing, and that's why I have the question underneath there, is a royalty conveyance. You can sever, as many of you know, you can sever the royalty from the minerals as well and deed out part of the income that would be generated by it. And I've had this discussion with a couple of colleagues as to whether you can lapse a royalty conveyance. And my thought is yes, you can, because a royalty conveyance is an interest in minerals. It's derived from the oil, gas, clay, uranium, etc. We have no case law on it as of yet. I have done it. I know colleagues that have done it, and I take the position that it can be done as of right now. So now if you're the severed mineral owner and you're worried about being lapsed, you need to use your minerals. So what's a use? We have production, obviously, oil coming out of the ground. Operations, the drilling of a well, reworking of a well, extraction of oil, again. A lease, a mortgage, an assignment, a conveyance, all our uses. It has been unitized or pooled, and that unitization or pooling is of record. The taxes, there's taxes being paid on the minerals. We don't assess taxes on mineral owners that I'm aware of, or on minerals. Or a statement of claim has been filed. Interesting to note that payment of royalties, bonus payments, or other payments to accounts on behalf of persons who cannot be located is not a use. I was talking to Judge Nelson this morning, and there are a number of these trusts that are established in the district courts for unlocatable mineral owners, where companies come in, they're going to drill the well, and they pay a bonus to a trustee, and it's put on deposit. According to statute, it is not construed a use, so you can still lapse that owner potentially. The main route that people go to preserve their mineral interest is the statement of claim in 3818.104. And there are several requirements to the statement of claim. It must be recorded by the owner or the owner's representative prior to the end of the 20-year period. It must contain the name and address of the owner. It must contain the legal description. It must identify the type of mineral interest and be recorded in the county in which the mineral interest is located. What does this accomplish? It's now in use. That's the statement of claim is deemed to use. Essentially, it's like a conveyance or an assignment, and it resets the clock to the date that that instrument's recorded. So the 20-year period begins to run again. The statement of claim filed after July 31st, 2009 by a person other than the owner of record is not effective to preserve the interest unless accompanied by a reference to the name of the record owner and whom the owner of the mineral interest claims. So, I've seen this a number of times. I've had clients call and say, Mom died and she had these minerals, and we're not sure if she signed any leases, and we want to preserve our interest, and she hasn't had a probate open in North Dakota. That son, daughter, grandson, granddaughter has got to make a reference in the statement of claim of who they are, how they're claiming through this, and who the record owner is, or it will not be effective. Even though you don't record your statement of claim within the 20-year period, you still can record it within the 60 days of the date of the first publication of the notice of lapse. So the surface owner has gone to lapse, and you've received notice either in the mail, as we'll get to in a minute, or by the publication. You file your statement of claim in the 60 days, your interest will not lapse and cannot be claimed. So if you're going to go the route and lapse minerals, you have to file a notice, or you have to file a notice of lapse. This is where the surface owner gives notice to all lapsed mineral owners that the interest has lapsed. They must make it by publication once a week for 3 consecutive weeks in the official county paper in which the interest is located. If the address is shown of record or can be determined upon reasonable inquiry, notice must be mailed within 10 days after the last publication. Now, 3818.106 has been the subject of a lot of controversy, and we'll get to that a little bit later. Basically, find an address and mail, and I'll get into a little bit more detail on that. The contents of the notice of lapse must contain the name of the record owner of the mineral interest, the legal description where the interest is located, and the name of the surface owner. And according to statute, for prima facie evidence that the statute's been complied with, you must record the affidavit of service, the affidavit of mailing, the affidavit of publication, and a copy of the notice of lapse to show that you've complied with that portion of the statute. So the biggest issue we've been dealing with the lapse is reasonable inquiry. And I put a question mark there is because I still don't even know what reasonable inquiry is. Even though it's recently been defined, it's an interesting subject. 3818.106 was a recent revision to the abandoned mineral statute in 2009. This went into effect, I think, July 1st, 2009. And it tells us exactly what we have to do as attorneys to constitute a reasonable inquiry if an address isn't of record, and I'll get more into that in a bit. You need to conduct a search of the county records for the existence of a use. So the recorder's office, you'd be running the tract index. You need to search the clerk of court's records for any judgments, liens, or probate records which identify the owner of interest. It does not specify which county you're supposed to run. Obviously, you're going to run the county in which your minerals are located, but I don't know if to constitute and comply with a reasonable inquiry, you need to run every county in the state of North Dakota because they could have moved. That is undefined. You need to check the Social Security death index and see if the person is deceased. Again, that's can be difficult if you don't have a Social Security number. I had to search Roger Smith, and I think I got 12,000 results. I don't know which Roger Smith it was, and that's what I had to tell the court in my affidavit of reasonable inquiry. And then one or more public internet databases to try and locate the owner or any known heirs of the owner. Again, another interesting portion of that statute that the legislature gave us. And how do we determine who might be an heir when we do a Google search or a white pages search? You know, there's literally millions of Smiths. It's a very challenging subject to get into. So when is this required is the ultimate question. The first piece of case law in North Dakota that dealt with the reasonable inquiry and addresses is Spring Creek Ranch. Basic holding in there is that the Supreme Court said you have to always do a reasonable inquiry. The real issue in this case was what constituted an address. I believe the plaintiffs in this case mailed something to like Los Angeles, California. You know, Fred Smith, LA, California. There was no street, no number. I think that was the basic holding there. This is an interpretation of law, again, pre-2009 amendments. So we have our new holy trinity of reasonable inquiry, and a question mark again there because I'm not quite sure how much direction it gives us as lawyers or you as land professionals or even surface owners who may want to lapse. And the three cases are the two Sorensen cases and the Talaferio case. All of these, again, are pre-2009 amendments, but these were cases in which the lapse was done before the legislature gave us 3818.106.1, which defined reasonable inquiry, but were litigated and attempted to quiet title after those amendments went into effect. What the courts came up with this here is that a reasonable inquiry is only necessary when there is no address of record. And if you see Fred Smith, Los Angeles, California, do a reasonable inquiry. That's not going to be an address. The holding in these cases seems to be in conflict with the 2009 amendments of adding reasonable inquiry and also defining perfecting title by using a quiet title. So again, here we discuss 06.1 of 3818.1 that allows for quiet title action to complete the process and perfect title in the surface owner. Well, we've always been able to do it, but now it's been codified that you can do a quiet title to obtain good title. I know a lot of land professionals that were dealing with lapsed and abandoned minerals were not taking leases based on a notice of lapse only. They were telling surface owners or requiring that you've got to do a quiet title before we're going to take a lease. It states that 3818.106.1 subsection 2 states that in an action under this section, the owner must show that all procedures required under 3818.1 were properly completed and a reasonable inquiry was conducted. So the provisions of 3818.1 are in contradiction. They're telling you in the case law that you only have to do a reasonable inquiry when there's no address of record, but then in the next section, if you go to quiet the title, you need to tell the court in your affidavit of proof that you've conducted a reasonable inquiry to locate these people. So, my suggestion ultimately ends up being do a reasonable inquiry no matter what you find in the record or in the county recorder's office or in the clerk's office. Further revisions, subsection 4. This might be relevant to you who are landmen, land professionals, or work for operators, that if you take a lease from an owner who has obtained a judgment pursuant to this section, you're considered a bona fide purchaser, and that lease will remain in effect even if the judgment is subsequently vacated, and you have no liability to those potential third parties who are vacating the judgment for lease payments, bonus payments, royalties, or other proceeds before that judgment was vacated. That's not to say the service owner may not end up being sued and have liability, but you as the operator have no liability if that quiet title judgment's been taken. So, do I have to do a reasonable inquiry after the 2009 amendments when the address of record? We just kind of talked about that. I would do it. Your judge is not going to sign the quiet title action if he doesn't see that you've done it and that you've specifically stated what you did, that what databases you checked, the Social Security death index results. I mean, I know I've run off the pages before and attached them as an exhibit in my affidavit saying, here's my results, 9,012 for Jim Smith or whatever. So, it's still, ultimately until the court makes a decision, it remains unknown whether or not you have to do that reasonable inquiry prior to quiet title. Justice Vanderwall in his concurrence addressed the situation. You can read it, but the long and the short of it is we don't know how it applies yet because that's not what was appealed to us. The wise choice again would be do your reasonable inquiry at the lapse stage and mail it to, comply with the statute accordingly. And I went really fast. That's all I have. There's not a whole lot there. I'll take any and all questions you guys might have. Yes?
Is there any recourse, like the mineral owner, a month after the quiet title action is found? Is there any hope of him getting his mineral back?
Well, they do have the ability to attempt to vacate that judgment. If you've gone to the proceedings and filed and obtained judgment, they can come in and attempt to vacate it because it is essentially you're going to be taking the default judgment against them, and the courts are very liberal in allowing somebody to come in then and try and defend. So they do have an attempt to recourse it, absolutely. Yes, sir.
We have a similar lapse statute in Ohio.
Mm-hmm.
Good luck with it. But here's my question. In the cases that you pursued yourself, what percentage of the cases do the mineral owners show up or file their affidavit within the 60 days?
Very few. When I initially started doing it, I was more in quote-unquote oil country out here, and I did see more statements of claims coming up. It seems that now the practice for those doing it are more on the fringe. They're gambling that it's going to get there eventually and want to do it now before it gets hot and heavy and then everybody wakes up. But, I think maybe I've seen a handful that have either contacted me and said, hey, we're here, or filed the statement of claim or hired counsel. It's been very few in my practice.
In the future, we're just going to use the microphones for the question because we're recording this so that other people can benefit from this. So if you would wait to ask your question until we get a microphone to you, please. Anybody have a question?
To your knowledge, is there anything pending in the current legislative assembly that would affect lapsed or abandoned oil interests?
Not this session.
Mineral interests?
No, not right now. I would like to see it happen. I think we need some more explanation. Yes, sir.
The statute says that failure to record a statement of claim within 20 years is not fatal if it's filed within 60 days of the notice of lapse. If it's been, say, 21 years, but there's no notice of lapse that's been filed yet, is a statement of claim still a valid use for renewing your 20-year term there?
I think it would be, in the sense that you've gone and made that effort. I think if you strictly read the statute, it probably isn't, but my guess is that our courts are going to say, well, they've made their statement of claim. You slept on the lapsed interest as the service owner. They're going to shift that burden back over to the service owner now saying, they filed the claim. The clock starts ticking.
When filing a statement of claim for mineral interest, is it important to attach supporting documentation behind that to include, for instance, judgments, decree distributions, et cetera, that would prove your position? I see a lot of those out there with just a statement of claim chopped off and notarized.
Well, pre-2009, all you had to do, you didn't have to prove who you were, essentially, if you were not the record title owner. So, yeah, now post-2009, if you're not the last owner of record in the tract and you're making a claim, you can absolutely put attached supporting documents. I've done it for clients as well.
All right, sir. Thank you.
Yes. Any other questions?
If you're within the 60 days of the lapse, will an oil and gas lease completely take the place of that claim? Or do you have to file the claim as well?
I'm sorry. Okay, there you are. I couldn't see it. No, the oil and gas lease is a use.
Okay.
So if that oil and gas lease is taken within that publication time frame, that would be a use.
And you don't need to file the claim as well?
You wouldn't have to, but as lawyers, I would file it for my client on error on the side of caution, CMA.
Okay.
Anybody else? Any other unrelated questions? I'll take them on oil and gas. We got one down here.
How critical is the timing of the mailing of the notice? I had one case where the notice was mailed before the first publication, and a district judge said that was to require it, or to say that was wrong, was to exalt form over substance. I have another case right now where the notice was mailed 12 days after the last publication.
Mm-hmm.
How critical is that timing in your opinion?
Well, we've taken the position, or it seems the courts have taken the position of strict construction to a point, and I believe the statute states it must be mailed within 10 days of the date of the last publication.
10 days after.
Yes, yeah, within 10 days after, anytime, right. So I wouldn't mail mine before I've published the first time, because in reading that statute, it's talking about publication, so it hasn't hit the paper yet. I usually do it after the second publication is my practice, because it's already run twice, and I'm within the time frame that the statute calls for.
What if you've got an address like from the 70s or 80s, but you've got a full address, zip code and all that, and you just mail it to that to stay within what Supreme Court said is all you need to do?
If that, in terms of doing a reasonable inquiry on top of that, or is that just the last address of record? I want to make sure I answer your question right.
It's the last address of record, and would you just rely on that and say, I don't need to do anymore, or would you still do reasonable inquiry?
I'm still going to do the reasonable inquiry, because if I get to quiet title, I have to tell the court, according to statute, that I've done a reasonable inquiry in trying to locate these people. So I'm going to do it, and if I find a new address, I'm going to mail it to both. Just again to cover my, CMA. But I've run into it where I've done that, and I've got 7 different addresses, so it becomes an issue of, what do I do? Am I even mailing it to the right person? But you always have your ultimate fallback on the last address of record. That's the record title owner. You're at least mailing it to the right guy, whether or not he lives there anymore or not.
What are your thoughts on the issue of, does that severed mineral interest vest in the surface owner as soon as they're dormant, or does it take the quiet title action to get it to vest in the surface owner?
Well, the statute says it vests immediately upon the expiration of the lapse period, but, the case law and just general practice would state you don't have good title and don't have ownership until you do that quiet title, because you're not an owner by any sort of conveyance. That would be my general take on
This is a little off the topic, but with the increased use of the internet and other modern technology, should public notice really be limited to the county newspapers, in your opinion?
Well, you know, that's interesting in the sense that if we're going to go outside of the newspaper of the county to give notice, where are we going to go? I mean, if you put it, where are you going to post it on the internet? Are we going to have a universal site for lapsed minerals? Maybe. But then again, also the county paper, I think, is also antiquated in the sense that most of these people, when I have even been contacted by them, they don't live in the state. They haven't seen the notice, but they've gotten it because of the mailing requirement. Yes,
I have a question about vacated judgments.
sure.
If you get a vacate of a partial judgment, or like partial,
Partially
partial-
vacated?
there you go.
Yeah.
Does the lease on the property cover all of the property still, or is there room for a new lease?
It seems to me that the way the statute's written is that lease is going to be effective. But I think that can be attacked because if you successfully vacated that judgment and you're the owner and you didn't execute the lease, you shouldn't be bound by its terms, even though the statute says that lease remains in effect. There's just no liability by the operator to that actual owner for any monies that were paid. Yes, sir.
If you have an unlocatable mineral owner under a producing well, have those minerals been abandoned?
No, I'm sorry, go ahead.
Well, my follow-up question is, if the surface owner, if they're determined that they're abandoned, and the surface owner goes through the process, at what point does he get paid royalties?
I don't think he can, because if there's production, that's a use, even though the owner's unlocatable. You know, it's pretty clear production is a use.
How about deceased and no known heirs?
That, I think, eventually will end up with unclaimed property then if there's, you know, you've got a decedent with no known heirs. I haven't run into that yet. That's interesting, though.
I have.
Anything else?
You said that Chief Justice Vanderwall they haven't had the question of what constitutes reasonable inquiry. What would you prefer? What would be the ideal for your job from your perspective?
I'd like to see it go away completely. You know, and there are others that think that the entire statute should go away. But they have good intentions with the reasonable inquiry requirement, but I would like to see it defined as to that we just need to do it, period, and then have a little bit more detail as to what exactly they want us to do, because it's a matter of interpretation. I mean, the facts of every search are going to dictate whether it's reasonable or not, and every judge is going to have a different definition and application of the facts. So ultimately, I think I'd like to see it just disappear.
So the things in the statute are where you would start.
Yes, it's a roadmap, and whether or not you go over and above that basic roadmap is up to you, and whether or not a judge thinks or a court thinks that you properly comply with that roadmap is a matter for their interpretation.
Hi.
Hello.
I'm wondering what advice you have for new law grads looking for work in oil and gas.
Well, if you can find some place to live, that would be the first start, and then hang out a shingle and go to work and beat the street. I tell you, there's a plethora of work that may not be directly oil and gas, but is oil and gas related out there. It just seems like my phone rings off the hook some days. There should be no reason to be a starving lawyer in Western North Dakota.
This is a question from the audience, but I'm going to ask it. Do you
Sure.
have an opinion about whether Section 3818.106 violates due process or the 14th Amendment? There was a recent Supreme Court case that kind of touched on it, and I'm not sure if you're...
I didn't see that one.
No.
I don't think I fall back on this kind of answer that question. The issue of kind of this abandoned mineral issues was addressed by the U.S. Supreme Court in the late 70s, and I forgot the case's name. And Indiana had a straight taking statute that after a period of time, they're gone. The surface owner gets them. That was upheld as a constitutional taking. So the fact that we go through a process of having to give notice and find these people, I think just bolsters the fact that it would be an acceptable form. All right, there's nothing else. I thank you.